Good morning. All right, this is case number 23CV258, Robert Pickering et al. Versus ProMedica Skilled Nursing and Rehab Center. I see Mr. Blake Dixon appearing. He is the plaintiff's counsel, and then who is counsel for defendant?
Your Honor, I'm Bob Ansbach. I am counsel for defendant.
Okay.
Also on the call, if it's okay with the court, I have attending with me Rashad Dowdy, D-A-O-U-D-I, who is a third-year law student at the University of Toledo, who is working with me on the case and helping me out. If the court has no objection, I'd like him to be able to just sit in on this.
Well, this is a public hearing, so this is no problem. Now, before we begin, though, Mr. Dixon, apparently you have not read the local rules. Local rule 1.9 provides that any attorney that appears in front of the court, whether it be in person or by video conferencing, is to be dressed appropriately, and that specifically includes a tie as well as a sport coat. So we'll take 5 minutes for you to go find a tie.
I have to go home, Your Honor. There's no tie in my office. I apologize.
All right. You better read the local rules.
Yes, sir.
One of the things that continues to amaze me about attorneys, and for our law student, I'll give him a little education from a judge's perspective, and that is that when you go to any court you go to, the first thing you do is look at the local rules, make sure that you comply with them. Obviously, you've not done that, Mr. Dixon, and that will be the last one that you'll get a free pass on. And I can't understand why any attorney would think that a court proceeding is not worthy of addressing appropriately. You know, just because we do this on computer doesn't turn it into a video game. It's a legal proceeding in a court of law, and you should dress appropriately and act appropriately.
Yes, sir.
All right. Now, I have read the pleadings, counsel, and the memoranda, and I don't, unless you have something new to add, I don't need to hear any argument, but I do have some questions. So is there anything new that you would like to add, Mr. Ansbach?
Your Honor, we are happy to, if the court feels that the court is completely advised, we are happy to just answer whatever questions you may have.
All right.
I do have things I could raise if you would like to hear them, but I am fine with going the way you suggest we go.
Mr. Dixon?
Yes, Your Honor. In addition to what we've raised in the pleadings, with respect to whether or not the court should stay discovery at this time, I have asked Mr. Ansbach to negotiate a stipulation with me to address the Clausen case decided by the Supreme Court regarding whether or not individuals need to be named as defendants. Mr. Ansbach has indicated that he and his clients are not inclined.
Now, that's not what this hearing is about. I asked you if you had anything about the protective order.
It's about discovery, Your Honor. The protective order.
No, we're not here on discovery. We're here about, well, we are here on discovery, but right now I want to just ask if there's anything new. And I saw the Clausen issue raised in the correspondence in Exhibit G. All right. All right. And I'll address that at the end of the discussion on the protective order. All right. Well, first of all, one of the things that when I was looking at the discovery request is, and I don't see it in the complaint, the specific time frame we're talking about. Your complaint refers to at all times involved or something like that. And I did see one discovery request that asked for information for as far back as 2018, which would be far prior to the statute of limitations. So what is the specific date that you're alleging, or generally alleging, there was a failure to comply with the statute of the standard of care?
Mr. Pickering was a resident of the ProMedica nursing home from November 17, 2022 through December 16, 2022. So about a month.
All right. Now, in the memorandum that Mr. Ansbach filed regarding his motion for a protective order, he stated that records were provided pre-filing on April 26, 2023. Is that correct?
Some of the records were provided at that time. I got an email from Mr. Ansbach's office yesterday.
No, wait a minute. I'm just asking you, did you get records back in 2023?
Some records, yes.
All right. Now, Did you ask for any further records after that before you filed this lawsuit?
Not from Mr. Ansbach prior to our discovery request.
Did you ask for from the defendant any other additional record before you filed this lawsuit?
Those were the records that were produced to us in response to our request from the defendant. That was pre-suit.
Okay, and after that, did you make any further requests prior to filing your lawsuit?
Not prior to filing a lawsuit, no, sir.
All right. And have you submitted any records to an expert yet?
Yes, sir.
And have they indicated they don't have, they think that there are records missing?
They have not told me they don't think that they have records. I mean, there's a whole...
Okay.
This is with the nursing home records, but nobody has indicated that records are missing, but I did get another set yesterday.
All right, well, your motion indicated that you, when you asked for this extension, I granted it, you said that you had not received all of the records. And yet it appears then from your statement that you got records in April 23, made no further request, filed your motion, and represented to the court that you hadn't received it without taking all records and without taking any affirmative steps, it appears to me, to ensure that that's the case. And then, don't interrupt me. You're already on thin ice. Now, in your memorandum contra on page 2, you said you wanted to make sure that you had all of them, and one of the things you talked about is, you've sometimes in a malpractice action, records are received, and then after trial they're different, and you didn't want that to happen. Okay, I understand that, but the fact of the matter is that what we're here about is the affidavit of merit because you didn't file it, and I gave you an extension. And I've done this on many, many occasions in my 15 years on the bench, and this is the first time I've seen, this kind of thing take place where, the requests for discovery aren't merely to the affidavit, but are broad. I mean, this was basically every document's ever been created in that period of time about anybody that ever lived or worked there. So, in any event, I am going to grant the motion in part because I agree that it would be burdensome and unduly expensive to allow broad-based discovery to take place until such time as an affidavit of merit is filed. For one thing, I have no clue from reading the complaint what the alleged standard of care was that wasn't met. I can't tell what the alleged injuries are. I don't know if you fell out of bed, if you got the wrong medication, if something happened. There's no way to tell. And the affidavit of merit, that's the purpose of that, is to put in to the complaint so that the defendant and the court are aware, here's what the allegations are, here's what the standard of care was that was breached, here's what the injury was, and this is in that breach of the standard of care caused that injury. And so at this point, and the discovery requests, like for instance, asking for every personnel record and timesheets and financial statements and blah, 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 that's not related at all to the affidavit of merit. So I'm going to allow the discovery to take place as to those items that I believe would be directed to the issue of the obtaining of an affidavit. So the request for admissions are stayed. The discovery will be stayed except for the following. Answers to interrogatories 1, 2, and 3. Yes, 1, 2, and 3. Production of documents 1 through 5, with 3 and 4 being limited only to those that pertain to the standard of care or the medical care that was provided. And then item 10. Now, Mr. Dixon has indicated that he did get some additional records yesterday. I don't know if those are in those items or not, but I want that to be done. And this was filed on the discovery requests were filed on February 1, is that correct?
That's correct.
All right, so you'll have until February 28th to provide that, but to the extent that you could do it sooner, you know, you should endeavor to do that. All right. And again, this is just staying this discovery. This is not ruling on any of the discovery themselves, although I will just note in passing that there did seem to me to be some requests that were very, very broad, and also some that may even ask for information about other patients that would be potentially prohibited by HIPAA. So again, I'm not ruling on any of those things at this time, but just on the stay. All right. Now, with regard to discovery about the names and so forth in the Clausen issue, again, I think that can wait until after we see the affidavit of merit. And I'll just say this, you know, I've been involved in, I've been practicing for, it'll be 48 years in April, and I've involved in several malpractice issues as an attorney, and including some federal tort claim cases against VA Hospital in Cincinnati and the Wright-Patterson Hospital. I'm familiar with these cases, and I've done quite a few here as judge in the last 15 years. I don't see any need to have 300 defendants in this case, Mr. Dixon. You know, you're going after the companies with the money, not the housekeepers and the cooks and the cafeteria people and the people that work in the office. And so when to the extent that you're asking for that kind of information, you know, if they object, you know, I'll rule on it. But, you know, this case is about, you know, the standard of care. You don't even have to know the identities of the people that didn't provide the standard of care if you're talking about STNAs and nurses, because you're going after the company. They're the ones with the money. So, you know, to that extent, you know, I've never had this happen in a malpractice case. And, you know, this case is not going to get out of hand. We're going to focus in on the issue and targeting those people that are involved in that issue. And if you don't know who they are, well, then you can go with a John Doe, because again, you're going after them because they're agents or employees of the principal, and that's who you're after. So keep that in mind. That's the way I think this kind of litigation could happen. I can't imagine any judge allowing 300. And if there's 300, that's just the John Does, not to mention the other 14 people who've been named, plus 3 corporate entities, or maybe 4. But, you know, this is not going to get blown up to every person that ever worked for that company being named as a defendant. That's just not reasonable. It's abuse of process, in my opinion. All right, now, is there anything else that counsel would like to discuss? Mr. Dixon?
So I have a question, Your Honor. I couldn't agree with you more. And in every one of my cases, other than this case and one other, I've entered into a stipulation with defense counsel that says just that. We don't need to name the employees, and then I promptly dismiss everyone I named other than the principals. My worry is that given that this case is fresh, and so the 180-day period has not gone by, the 1-year period has not gone by, my worry is that once we're past the 1-year period, if defense counsel were to file a dispositive motion and say you didn't name the agents under Clausen, this case should be dismissed. I've heard your opinion on it. I agree with 100%. I know there are other people that don't, so that's why we try to protect ourselves with either a stipulation or naming the agents. I don't want to name the agents in any case. And in the one case where I've been forced to, you're 100% correct. It is a mess. So do you have a suggestion as to how to address that now prior to the expiration of the 1 year so that I'm not in a jackpot later when it's too late to bring people in?
Well, Mr. Ansbach, I assume you've heard everything I said. What's the problem with entering into that kind of a stipulation?
Number one, he already named a number of individual defendants. Number two, he simply asked for a Clausen stipulation. Given the individual defendants that he had already named, I did not initially agree to signing a Clausen stipulation. And as you've already pointed out, Your Honor, he also added 300 John or Jane Does. So at the initial, I received a letter from him requesting a number of things. I have talked to my client about sometimes the Clausen decisions, stipulations that are requested go well beyond what our client is willing to.
Well, I haven't seen the stipulation, so, you know, I can't speak to that. But it would seem to me that if there is any liability, I mean, you would identify what employees' actions you feel might have constituted a breach of the statutory duties or the standard of care, Mr. Dixon, and those would be the ones that I would think you would do. I mean, again, I don't see any point in, you know, unless you're alleging that he was poisoned by bad food or something, the cafeteria, the cooks, slip and fall, housekeeping, or the housekeeping didn't appropriately clean, so therefore he got a bacterial infection. Again, I don't know what the allegations are because we don't have an affidavit of merit. But what I'm saying is I think he has a point, is you did name some people specifically, I don't know, and I see some of them haven't been served. I don't, at least initially have been served. I haven't looked at, didn't really pay much attention to the service other than initial. But in any event, it seems to me that if you can identify the class of people, agents and employees that are in question, unless, now there could be some that you feel are specifically liable, like if there's a doctor or, you know, somebody like that, or some other, you know, medical professional that might have their own business or contract or whatever, again, then, you know, I understand that those people would need to be specific. But to the general term, again, I don't know how many employees are out there, probably a couple hundred. There's no reason for that to happen. So again, Mr. Anspach, I would hope that, you know, if he will narrow it down like that, you know, so that we know that what we're talking about are those people for whom, if their acts were below the standard of care or a violation of a statutory duty that might result in liability, those are the people we're talking about, whether we know who they are or not. Because, you know, I mean, turnover in nursing homes is, you know, amazing. It's like a restaurant. So, you know, I mean, I'd be amazed. I mean, I'm sure they maintain their records, but, you know, just trying to deal with that and locate those people, just from what I've seen in the file, that's not going to happen. So, you know, to that extent, I think that the Clausen stipulation, as long as it's reasonable, needs to be done in this case. So.
Your Honor, I'm sorry, I have no problem with that, so long as it is reasonable and specific. I would like to add, with regard to Mr. Dixon's statement, that time is quickly running out. If I calculated correctly, the 180 days does not run until June 15, which is what, about
4 months.
May, yeah, four months from now. And of course, Mr. Dixon filed this complaint when he did, even though he had received 1,024 pages of records back in April. And I would also note that in June, the attorney who provided these records, Your Honor, was an attorney in my office named Tom Kirkham. He's no longer with the firm, but there's a letter from Tom sending and he's not questioning this, Mr. Dixon's not questioning it, sending the 1,024 pages back in April. There is another letter from Tom, but I cannot guarantee that it was sent in June, which sent 15 more pages to Mr. Dixon, but I can't guarantee, so I won't say it, that was absolutely filed, because Tom's no longer with us. I haven't been in a position to ask him.
Sure.
Those 15 pages, to make sure he had those, were provided yesterday. Those are the business file. They included things like, for example, an arbitration agreement. In this case, it's unsigned. So we sent him those additional 15 records yesterday. The only other thing, Your Honor, I'd like to mention, since you mentioned local rules, and I'll just represent the first thing that Rashad did in the case is look at the local rules. There's one other that I wasn't going to mention, but I think I should mention it now. I believe the local rules specifically say, right up front, this is a courtesy. When we received Mr. Dixon's brief on the day that it was filed, I believe Wednesday, from the court, notice of electronic filing, the first line, if I'm reading this correctly, says this is a courtesy notice only and does not constitute service in any manner. I do not believe, and I've confirmed with my paralegal to make sure I haven't missed it, that we received any service of Mr. Dixon's brief in opposition from him. Now we have it because we got it from the court. I very much appreciate that. But going forward, I assume that we will all comply with the local rules. Thank you, sir.
Yeah, we're in the process of implementing the e-filing, and that's why we put that in there. I'm going to take it out here within the next few months. Because we're still working our way through. We still haven't fully implemented it in criminal cases, and we just started in DR. So it's so that's the reason that's in there, to make sure people understand that you still need to do an electronic service, or under the rules, or paper service. I think most people do electronic service now. That's the best way to do it. But yeah, so since you brought that up, yeah, I just want to make it clear that that's the reason that's in there. Is I wanted for a period of a year or two to have duplicate filings to make sure that the system's working the way it's supposed to. And like I said, and my clerk's been out because his wife broke her leg on a vacation trip in Texas, and so we've had, and then we've had some other things over the last few months with health issues and so forth. So we're still working through that. So that's why that rule is there for everybody's. But again, I will say this: I've had cases where people haven't done it, expecting it to be sent by the clerk, and I, haven't held their feet to the fire, because again, I know it's the most people with electronic filing now, they just rely upon it to serve everybody in the case. And like I said, we're still kind of working through that.
And as I said, I wasn't going to mention it, but since you mentioned local rules.
Sure. Well, I'm glad you brought it up so that we can clear that up. I appreciate that. So, yeah. And like I said, I haven't had a chance to follow up with the clerk lately in terms of seeing just how well that's working, because to the point where it gets to be as close to 100% as we can expect, then I'll, remove that from the local rule. So, okay. Anything else, gentlemen?
Just, Your Honor, I do have one question, and you may not be able to answer it. I'm not sure if Mr. Dixon can, maybe Rashad can. With regard to the ones that you've told us to answer, do you know offhand, or Rashad or Mr. Dixon, do you know offhand, do those include multiple defendants, or are they separate interrogatories?
They were, the way I read the interrogatories, they were identical, weren't they, Mr. Dixon?
Yes, sir.
Yeah.
Okay.
Yeah. Because when I went through them, I read them through. I've read them several times, and just for that purpose. And I can't say that I read every single word of the other second and third copies, but the way I read it, it was all one. And yeah, I did. Was the audit call it spot auditing, checking different numbers to make sure they.
That's fine.
And I just assumed that, so I probably did a 10 or 20% sample. Yeah.
Great.
All right. Anything else then?
None for the plaintiff.
All right. I'll prepare an entry and put it on by the end of the day. Thank you.
Thank you very much, everybody.
All right.
Have a good weekend.
You too.